And according to that little red dot, we are live. So if you are joining me and you had just watched Wills and Trust in 20, welcome to the McClear Law Office, mobile office, we'll say, satellite office. I'm in the basement of my house. So not the most aesthetically pleasing, but this is where I've been doing a lot of my work for the last couple of weeks. Probably will for the foreseeable future. So this is the first time I'm doing live. Hopefully everybody can hear me. So let's get a couple of points out of the way. Uh, if you have any questions about what you saw in Wills and Trust in 20, or if you have any other questions that you've already had about, we're going to stick to wills and trust and basic estate planning here. So if you have any of those questions, and I have had some pre-submitted from the Oshkosh Senior Center, so thank you for co-sponsoring this event, co-presenting this event, Oshkosh Senior Center, very much. A couple of points, though, just by getting questions answered from me today does not establish an attorney-client relationship automatically. If you want to learn more about these topics or anything else that I work with, which is all forms of estate planning, long-term care planning, special needs planning, and disability planning, you can schedule a free initial appointment with me, which right now I am doing remotely, entirely remotely. So this would be done over the phone or over a video. So if you want to have one of those set up, they're free. They take about an hour. Just give me a contact. You can contact me through Facebook. You can email me at joe@mcclearlaw.com. You can call my office. I still get my office number here, 920-221-0320. If you have any questions, I ask you to maybe not make them so detailed that they might only pertain to you. So if you do have questions and they're of a general variety, go ahead and post them. If you have something that's very, very specific, I would suggest you schedule an appointment with me before so we can talk about those. So I had a couple questions submitted first, and I'm not sure how long this is going to last. I'm going to end at 5 at the latest. So it's 4:21 right now. I'm going to end at 5 at the latest, really because that's when I can start eating. I'm doing this thing called intermittent fasting. And I'm on a super fast now, so if it seems a little loopy, it's because I haven't eaten all day. But I can start. My window opens at 5, so I'm going to end this at 5 at the latest. But if this only goes 15 to 20 minutes, then okay, that only goes 15 to 20 minutes. A couple of questions. We're going to start off right here. First of all, from the Senior Center, Pamela submitted a couple of days ago a simple question, but very, very important. What is a trust? I covered this a little bit in the video, and it's common for me to use the analogy that a trust is a business that doesn't do any business. So like a business can own assets. My business owns assets. Google owns assets. But the people who work for Google, even the CEO and the members of the board, they don't own those assets. They can control them, but they don't own them. The business itself owns them. A trust is similar in that you can control the assets that are in your trust if you're the trustee. And if we're talking revocable estate planning, revocable trust, then you would be your own trustee, most likely. You control them like you own them, but technically the trust owns them. Now that's valuable because while you and I are going to pass away someday, trusts don't die with the grantor, the person who forms the trust. They continue on, so that's how they avoid probate. In the last couple of days, I thought of another analogy. Maybe this is even better. Let's picture a trust like a building, okay? You create a new building, and you put a bunch of stuff in this building. There's furniture in there, there's electronics in there, but everything that you put into this building is no longer yours. It's the property of the building. The building itself can own whatever you put into it. So yes, of course, you can put furniture electronics personal property in there. But this is a type of building that if you put your title to your car in there, then the building owns your car. If you put the deed to your house in there, the building owns your house. If you put the shares of a business you own or a co-owner in, then the building would own your business, or at least your shares of it. You can also title accounts, bank accounts in the name of your building. You can also title insurance policies in the name of your building, stock accounts, bonds, CDs. All of these things can be owned by your building. Now, the thing is, you could also leave instructions in your building that says, okay, I created this building, I control this building, but when I pass on, here's what's going to happen to everything within this building. And it's going to happen outside of probate. So you could say, okay, well, I'm just going to pass the whole building on to this person over here, whether it be my spouse, whether it be one of my children, or most likely what would happen is you're going to say, we're going to disperse the assets that are owned by this building out to these beneficiaries. And it's done outside of probate. So that's the second analogy that I would use for a trust. It's you're creating a new entity that will become a new owner of not necessarily all of your assets, but potentially majority of your assets. You would maintain full control over those assets. So you want to spend money, you spend money. You want to buy more property, you buy more property. If you want to sell something or invest however you want, you do it just like you do now. Your life is not going to change one bit. But because your trust owns these assets, then when you pass on, the trust has mechanisms in place to pass it down to whom you want to receive it. And it does it without probate. And when I generally would say that 95% of the value of a revocable trust, which, as I said in the video, is commonly used just for estate planning, 95% of the value of a revocable trust is what happens after you're gone. There's some value for when you are still here with us. A revocable trust, the biggest one would be that if you need assistance, then your family members, your spouse, your children can step up and become the new trustee, the new manager, essentially, of the trust, and can take over and help manage your property and manage your accounts. And when they have that ability to serve as your trustee, as opposed to your power of attorney, that tends to be more respected by banks, by financial institutions. If you have a power of attorney for finances, that could work, but if it's too old, some agencies may not accept it. But it doesn't matter when you form your trust. If you formed it 15 years ago and you say, if I'm no longer have capacity, then my oldest son or my oldest daughter will serve as trustee, then they step in, become trustee of the trust, and they're not going to have any issues controlling the assets of the trust. Okay, let me make sure I'm doing this right. Current moderation, not set. Follower, slow discussion, restricted, protected, none of the sort. Okay. I think I'm doing it right. As I said, my first time going live. Am I live over here? I got this page open on 2 screens. Indeed I am. So, all right. So, next question comes from Debbie, also through the Senior Center. Now, this is a big one. This is going to be very, very important. So, pay attention. What would be the differences / advantages / disadvantages to having transfer on death, or TOD, put on all properties and assets as compared to setting up a trust for adult children to inherit with the goal of avoiding probate? All right, so TODs and PODs are your common beneficiary designations. So beneficiary designation, if you have life insurance, you know what a beneficiary designation is. It's going to be who receives the proceeds after you die. If you have a qualified retirement account like an IRA, 401k, 403b, or a Roth, no doubt you filled out a beneficiary designation to say when I pass on, whatever's left in this account is going to go to my spouse or to my children or to my church or whomever. You probably know that you could also have those on bank accounts as well. TODs, transfer on death, POD, payable on death. I mean, you just cut checks and send it out to whomever. You can have it on stock accounts. You can have it on savings bonds. You can have it on CDs. You can also have it on real estate in Wisconsin. You can have transfer on death deeds. Now, the benefit to having these beneficiary designations, the TODs, would be you're avoiding probate. But that's pretty much the only only benefit would be. And that's a big one. I'm not going to lie. People who their sole goal is to avoid probate, and they don't care about anything else, then they can get by with relying completely on beneficiary designations on all of their assets. Even with cars, you can have it transferred to a spouse. Not so much to after you pass on, if you do not have a spouse. But your personal property, and it would include your vehicles, if that doesn't total up to $50,000, the probate court doesn't want to see you. If you have a will or you don't have a will, it doesn't matter. If it's not $50,000, they really don't want to see you. They will say, you handle it yourself, handle it by way of what's called transfer by affidavit. And it's done outside of probate. All right, so you're avoiding probate, most likely, if you rely solely on beneficiary designations. But there are a lot of problems with that. One big one is you're not getting the protections that you can with a fully fleshed out estate plan, whether it be a will or a trust. Or in this case, you want to avoid a probate, it'd be talking about a trust. So I mentioned in the video that you can protect inheritances for your children or your grandchildren, whoever you're going to leave them for, from divorcing spouses, from creditors, from lawsuits. So if they get into an auto accident, it's their fault. They get sued. They get into a contract dispute and they get sued. They could lose a lot of money. Or bankruptcy proceedings. They have their own business. It goes belly up. They have to file for bankruptcy. Well, they can lose a lot. But you can place protections over an inheritance such that they would not lose their inheritance. It would be protected in a safe way. And most estate plans that I see don't take advantage of this. You can't do it for yourself. You can't do it for your own assets. You can't say, in this state, I want to form a protective trust that if I ever get divorced, I'm not going to lose any of my assets. If I ever get sued, I'm not going to lose any of my assets. If I ever file for bankruptcy, I'm not going to lose my assets. You can't do that for yourself with a trust formed in this state. You can do it for your family or whoever you want to inherit from you. You can have that protected inheritance put on there, and that can last the rest of their life and then some. So if you leave a big inheritance to a child and they have it sitting there, it's protected. If they pass away before they spend it all, it can go down to their children, whoever they decide to leave it to, with the same protections. You can't do that with beneficiary designations. They take it as is. Now, they would be losing that protection. The other thing that could also be problematic would be if any of your beneficiaries were to pass away, you got to know where the inheritance is going to go at that point. You can put in your trust, say, if my child passes away, this is who's going to inherit. Beneficiary designations, they have it so they have secondary beneficiaries, they have contingent beneficiaries, and you can list those. But if you were to do that and it's somebody young, like if you want to leave something for a child and they want the contingents to be their children, which is pretty common, if they're too young, they can't inherit anything until they're at least 18. But even if they're 18, do you really want them to be inheriting money? At that point, what are they going to do? They're probably still in high school. I was still in high school. I was a good student. If I got a big chunk of change, I would have messed up my life. And I think most people could say the same thing. They would not be focused on their school, not be focused on work, building up strong work ethics, personal character. It's not going to happen. There are going to be too many distractions by having instant access to a large chunk of change. You can put restrictions in your trust to say, all right, if somebody's too young, it's got to be held back. At least control has to be held back until they're 25, 30, which are pretty common ages. And that's pretty smart planning. Further, if anybody is set to inherit and they're on SSI or they're on Medicaid, if you don't have smart planning, you can get them kicked off their services because those are means-tested programs. So, and it's pretty de minimis of what they're allowed to have. Say for Medicaid, if you're a single individual, it's a house and $2,000, just about. So if all of a sudden they receive an inheritance, even if it's only, a couple $1,000s, you can get them kicked off their program. You can have protections in place in your trust to say, all right, if anybody is going to inherit, whether it be a year from now, 20 years from now, and they're on a means-tested program at that time, then we're going to create it so that they would benefit from this inheritance, but it doesn't necessarily get them disqualified from their program. You can't do that with life insurance beneficiary designations. You can't do that with TOD deeds. If all of a sudden somebody on Medicaid is a beneficiary of a life insurance policy or receives a portion of a property as a TOD deed, they're probably going to get kicked off their services. That's going to be pretty tough for them. And lastly, the point that I would say to be wary of relying on beneficiary designations would be that I see people come in who are retired. They're in their 50s, 60s, 70s. And I asked, do they have an estate plan? They say, yes, they got it when their kids were kids. So 30, 40, 50 years ago. That is all too common. It takes a lot of people a good long time, usually, to actually get their first estate plan, and even longer to update it. Now, if it comes to a point where you should update your estate plan, do you really think it's a smart move to have a dozen different switches you got to check? This bank, this bank, this bank, this insurer, this financial agent, this piece of property over here. You're going to have to go through all of them to fix it. I fear that most people wouldn't. But if you have a trust, one that has proper backups in place to say if anybody's too young or if they're on SSI or Medicaid or if they have some sort of other issues like addiction problems or psychiatric issues like I mentioned in the video, that you already have that taken care of. But if you still have to make a change, it's much better if you only have to go to one place to make an alteration as opposed to going to a dozen places to make an alteration. They're much more likely to make that change. So, as I said, if the only goal is to rely on beneficiary designations, is to avoid probate, and you want to rely on beneficiary designations, the only goal, and that's it. It would work if you stay on top of things, but it's not very responsible, I would say. If you want to have a good plan with proper backups that's going to take care of your family and avoid probate, you should get a trust. All right, moving on. A couple more questions here. Paula asks, is there a thing as too much detail in a will? I'm going to hold off on this because she asked another question later on that kind of is similar to this. So I'm going to hold off on this. But she's another question. How have people taken care of their pets through a will or a trust? That's a very good question. Couple of different avenues. Some folks don't. They would say, okay, it comes down to that's part of their assets, that's part of their estate, and they trust their family to make the decisions of what to do with pets. But for others, they could be a little more specific. I've done a few times where I've specifically designated, say, a cat or a dog to a specific member of the family. Say, I trust this person to take care of my beloved pet. And they could just do that and say, okay, this pet is going to this person. Very common, I say, it would be nice to leave them a bit of money to do that. I mean, perhaps they're already going to be inheriting, but if not, if you're going to leave it to a neighbor, say, well, why don't you leave them a little bit of money, because it's, costs money to feed and take care of a pet and pay for their shots and take them to the vet. So you leave them a small bit of change as well to care for the pet going forward. There is such a thing as pet trusts. I've never done one. I know they're out there, but essentially what you do, you can create a trust that's going to hold some amount of funds that is specifically only can be used for the care of the pet. That may seem like overboard for some people. It's very, very important. Particularly, I mean, if you have a dog or a cat, I mean, what their lifespan is going to be. I had a cat growing up, lived to be 20. Dogs probably not going to live quite that long, but it could be a long period of time. If you have something like a exotic bird, those can live a long time, 50, 60, 70 years. So if you just got one and you're passing it on to somebody and you're saying good luck for the next several decades taking care of this bird, that might be a scenario where you say, okay, well, this trust is going to be there. It can accumulate funds through investments, but all the spending, all the money is just be there to take care of this pet, which could be for a long time. Has not happened very often in my experience. I've seen them advertised more than I have seen them actually play out. Most common, I would say, would be is you either you trust your family to decide what's best to do with the pet, or you specifically designate the pet or pets to go to one person, and if should probably leave some money to go with them to help, say this is going to be some work for you, so here's something to help it out. All right, so as I said, Paula had asked, is there such a thing as too much detail in a will? Later she asks, what conditions can you put on a trust as far as how the money should be dispersed or used? So the first question, is there such a thing as too much detail in the will? Let me first address that. Depends. That's a common answer for attorneys. It depends. For the details around the administration of the will, I doubt there can be such thing as too much detail. My wills are excruciatingly detailed. I see a lot of wills come into my office that I take a look, and they're 5 to 10 pages, sometimes less than that. My wills tend to be 50 to 60 pages, excruciatingly detailed. Because I want to make sure that the proper backups are in place to say, all right, well, if life throws a curveball at yourself or your family, that the estate can still work out in the best way possible for everybody involved. So, and I try to shrink my wills. I have. Came out a couple, like a year ago, I said, these wills are way too big. I got to go through here and see if I can shrink it a little bit. So I went through the will, said, what can I take out? What can I make shorter? And I ended up making it longer because I realized, well, actually, maybe I should add a few more things in here just to be on the safe side. But here's where it could be potentially too much detail. If you were going to list parameters by which an inheritance can be used, that could be a big pain. And it could be problematic. First of all, what you cannot do is to condition an inheritance upon certain triggers. You can't ask anybody to do anything illegal, obviously. But you also can't ask anybody to do what would be considered to be against public policy. So if you have a child and they married somebody that you don't like, you cannot say to my daughter will inherit half of my estate as long as she divorces that louse she married. Can't do it. That would not be enforced. Your daughter would just get the money, okay? You can't say, so something of the sort there. You can't put those type of directions on there. So those would be disregarded. But as a practical purpose, and this could play out into the second question, under what conditions can you put on a trust as far as how the money should be dispersed? It all depends. So if you were going to have a child inherit in a trust, that's where you can really put some strings on there. And you can have them inherit in a trust even if you start with your own will. But you want to do so delicately. If you were to say that this is going to be a trust to be used for my grandchild for educational purposes, and once they graduate or finish a certain degree of schooling, then they can just have the rest for their own general use. You can do that, but you would want to have somebody else serve as trustee. When somebody inherits a trust, if they're of sound mind, they got their act together, and they're of decent age, 25, 30, they could be their own trustees. So just like when you're your own trustee, you have full control over your assets. They can be their own trustees too. But if you want to put stipulations on them and want them to be adhered to, you're probably going to have to name somebody else serving as trustee. Now, if that's somebody if the beneficiary is too young and you name their parents to serve as trustee until a certain age, that's usually fine. That's common. But if it's, say, this is going to be used for only these purposes, for the remainder of their life, for education, for medical expenses, for housing expenses, and that'd be it. And say, okay, and then when they're 65, when they're at retirement age, then they can use it as a retirement fund from themselves. So you'd have to have somebody else watching over that inheritance, serving as trustee until they are 65, essentially. One, you're going to have to pay that trustee. So even if it's a family member, if you're asking them to be watching over that for that long, you're going to have to make sure that they're going to be receiving funds. So if it's a family, even if it's a family member, most likely you'd be talking about a professional trustee. Professional trustees are not cheap. So if you want to have those details in there that could make it restrictive, you can do it, but I would say tread cautiously. And make sure that if you are going to use them, make sure that the trustee can receive payment for the work that they're doing, whether they're professional or if they're family. And don't make it too difficult. There are certain what they call the cold hand. That's not. I don't think that's what it is, but it's something of the sort that I learned back in law school, saying you don't want to have your own control over this inheritance as it moves further away. After you pass on, eventually you just got to let go. So yes, you can have plenty of details in your will or trust, which is why mine are so massive. But it'd be my suggestion that you, when it comes to putting stipulations on how an inheritance can be used, to tread lightly in that. Okay, well, that's all I have for questions as far as what had been submitted beforehand. I don't see any that have come up. So apparently I answered all your questions already. It is 4:45. I could end it here. I'll give it another sip to see if another question is going to come in. If not, then I'm going to bid you all adieu and remind you that, again, if I answered your question, I'm still not your attorney. We got to have a written agreement for that. I implore you that if you have further questions and you want to set up a free initial appointment, which right now, as I said, I'm doing all remotely, virtually, via video, via phone. First meeting is always free. You call my office number, 920-221-0320. You can email me at joe@mcclearlaw.com. You can message me on my Facebook, my business Facebook page, and we'll set up a meeting at that point as well. All right. So I see no further questions. That is fine. I thank you all for the folks who have tuned in. Hope you got some good information out of this. This is my first live event. I am going to be doing at least another one, I anticipate, as long as we are in this scenario, because if you know me, you know I had been doing live in-person seminars, usually about once a month. Not possible right now. Probably won't be possible for who knows. So I'm going to do another one of these, another in 20. I'll probably do one on Medicaid, just straight on Medicaid, and then one on long-term care planning. If you have any other requests of anything that you want me to discuss in one of these seminars, let me know either here or shoot me an email, and I'll consider putting something together. Thank you all for tuning in. Again, give me a call or shoot me an email if you'd like to do an initial appointment. Everybody have a very, very good weekend and stay safe and be well.